My name is Jaswin bin Roslan and my matric number is 20DAT22F2004. Question 1. Tekun Niaga Berhad, an investing company based in Johor Bahru, had appointed Sarah as its sole auditor. In discharging one of her main duties as an auditor, Sarah completed her audit on the company's financial statements for the current financial year. Her auditing report will be presented in the upcoming annual general meeting. However, there are some issues arose where Sarah had negligently prepared her audit without adhering the right legal framework. Unknown to her, Salim, an investor who had suffered hefty losses as a result of his reliance on Sarah audited accounts, wanted to initiate a legal proceeding against her. In the meantime, Sarah had also provided her good advice for the company to extend credit to Excel Holding after being satisfied that it was appropriate to do so based on their current financial status and position at that time. Unknown to her, an unprecedented worldwide pandemic takes place shortly after, and now Excel Holding unable to settle their debts according to the contract entered. Tekun Niaga Berhad blames Sarah and now intends to sue for the losses suffered, as in their opinion Sarah had breached her duty by providing wrongful advice. The issue for this question is whether Sarah can be sued or removed by the company. According to Section 266, Powers and Duty of Auditor, subsection 1, every auditor of a company shall report to the members on the financial statement and on the company's accounting and other records relating to those financial statements, and if it's a holding company for which consolidated financial statements are prepared, shall also report to the member on the consolidated financial statements, and report shall be Subsection A. In the case of public company, laid before the company at its annual general meeting, or Subsection B. In the case of a private company, Subsection 1, Exception I, circulated to its member, or Subsection Roman II, laid before the company at a meeting of members. According to Section 277, special notice required for resolution to remove auditor from office. Subsection 1. A special notice shall be required for a resolution to remove an auditor from office at a general meeting of a company. Subsection 2. Upon receipt of the special notice of such unintended resolution, that company shall immediately send a copy of the notice to the auditor proposed to be removed and the registrar. Related cases for this question is Capero Industry against Dickman, 1990. Facts: Capero, a small investor, purchased shares in a company relying on the accounts prepared by Dickman. Capero lost money due to the accounts being negligently prepared. Issue: could Dickman be liable to Capero for the negligent preparation of relied upon company accounts, given there was no contractual relationship between the two parties? Decision: it was decided that there was a proximity between the parties and that there was foreseeability of loss and damage. The Capero test foreseeability, proximity, and fair, just, and unreasonable was failed due to lack of proximity. Allowing claim would allow liability an indeterminate amount for an intermediate time to an intermediate class. In claim for economic loss, there must be a common purpose, proximate relationship, non-communication with expected reliance and actual reliance. There was no proximity as the defendant knew nothing about Capero. In applying Section 277 Companies Act 2016, Subsection 1, A special notice shall be required for a resolution to remove an auditor from office at a general meeting of a company. Then, the auditor may be removed at the general meeting by a resolution passed by a majority of votes more than 50% of members, and another person can be appointed as an auditor at the same time. The company is required to give a notice in writing of the removal to the registrar within 14 days after the removal, in which the registrar would appoint an auditor in the company, did not appoint a new auditor, and the auditor cannot be removed by director. The conclusion for this question is the company no need to sue Sarah, but the company can remove Sarah from the company for being an auditor under section 277 subsection 1. Thank you, that's all from me.
Hi, my name is Arabella Grace. I'm a second presenter. Today I'm going to present about question 2. The situation in question 2 is Azlan is an auditor act for Bosku Sendirian Berhad had been terminated on 33 April 2023 by the company managing director on the ground that he is not competent and failed to execute his right duty. He who had only received termination letter in the early morning also found out that all his personal belongings were removed and vacated from his office in the company. With utter confusion and dissatisfaction, Azlan wants to challenge his termination as he feels that it was done in malafide and did not in accordance with the right principle and procedure under the Companies Act 2016. At the same time, Bosku Sendirian Berhad had defaulted the submission of annual return by lodging the document 2 months later than the company anniversary in January, without knowing that the consequence of such breach. It was found that was the company's third consecutive breach of Section 69 of the Companies Act 2016 since 2021. If you are appointed as an interim auditor for the said company, what would be your advice on the content, requirement, and principle with the regard of annual return? First issue for this situation is whether Azlan has a strong basis to challenge his termination and seek appropriate remedies. The definition of auditor is an auditor is an independent professional authorized to inspect, examine, and verify the accuracy of business record to ensure true and fair of past financial performance and current financial position. General rule under Section 276 subsection 1 subsection A of Companies Act 2016, resolution to remove auditor from office. Subsection 1, the member of a company may remove an auditor from office at any time. Subsection A, by ordinary resolution at a general meeting. Exception for this situation is under Section 277 subsection 3 of Companies Act 2016. Special notice required for resolution to remove auditor from office. Subsection 3, the auditor may make a representation in writing not exceeding a reasonable lag to the company within 7 days from the receipt of the special notice and may request prior to the meeting at which the resolution is be considered. A copy of the representation be circulated by the company to every member of the company to whom notice of meeting is sent. Section 284, subsection A of Companies Act 2016, duty to inform upon cessation of office. Subsection A, submit a copy of the written representation or his statement of circumstances connected with his resignation to the registrar. Related case for this situation is Re Company ex parte Smith, 1964. The help for this case is The court found that the majority shareholder had conducted the affairs of a company in a manner that was unfairly prejudicial to the interests of the minority shareholder. This typically involves actions that are contrary to the understanding on which the minority invested or that harm their legitimate expectation. In applying, according to Section 277, Subsection 3 of Companies Act 2016, special notice required for resolution to remove auditor from office, auditor was given the opportunity to defend himself or herself against the termination. Next, upon receiving the special notice, the auditor concerned may within 7 days from the receipt of the notice make a representation in writing to the company and request that a copy of the representation to be circulated by the company to every member to whom the notice of the meeting is sent. The auditor then shall submit a notification under Section 284, cessation of office by auditor, Companies Act 2016, to the registrar within 7 days from the submission of the written presentation. Last but not least is the conclusion. Therefore, based on the situation by the leveraging the principle established in this case and the statutory requirement under Companies Act 2016, Azlan has a strong basis to challenge his termination and seek appropriate remedies. Thank you. That's all from me. I'm gonna pass this presentation to our last presenter. Thank you.
Hi, my name is Emilia Asang. I'm the last presenter. And now we will move to the second issue for this situation. The issue is whether Bosco Sendirian Berhad has repeatedly breached Section 68 of the Companies Act 2016 by submitting its annual return 2 months late for the third consecutive year since 2021. Next, we move to the law for the situation. The definition is an annual return is a basic information of a company. Refer to Section 68, Subsection 1 of Companies Act 2016, which is duty to lodge annual return. Subsection 1, a company shall lodge with the registrar an annual return for each calendar year not later than 30 days, the anniversary of its incorporation date. The general rule is Section 576, Subsection 1 of Companies Act 2016, Annual Return. Subsection 1, a foreign company shall lodge with the registrar once in every calendar year an annual return in the form and manner as the registrar may determine. The related case for this situation is case Securities Commission Malaysia against Hong Song Construction, Sendirian Berhad and another 2019. The issue is whether the company failed to submit its annual return within the stipulated time frame. The fact is, in this case, Hong Song Construction, Sendirian Berhad failed to comply with the statutory requirement of submitting annual returns and financial statements over multiple years. The Securities Commission Malaysia initiated legal action against the company for non-compliance, emphasizing the importance of timely submission and the consequence of failing to meet regulatory obligations. The help for these cases is the court found that the majority shareholders had conducted the affairs of the company in a manner that was unfairly prejudicial to the interests of the minority shareholders. This typically involves actions that are contrary to the understanding on which the minority invests or that harm their legitimate expectations. Next is the application for this situation is, in applying, the company has a legal obligation to submit its annual return within the specified time frame to avoid penalties. Next, by repeating breach of Section 68 can result in fines, potential disqualification of directors and damage to the company reputation. Besides, Bosco Sendirian Berhad should establish robust internal controls and procedure to ensure timely submission of the future annual returns, including setting up reminders and checkpoints throughout the year. Moreover, the company can establish a system reminders and alerts to ensure that deadlines are met. So, this could involve setting up digital reminders well in advance of the due date. The conclusion for this situation is, based on this situation, it is imperative to advise Bosku Sendirian Berhad on the importance of adhering to the submission deadlines for the annual return and implementing measures to ensure compliance with Section 68 of the Companies Act 2016. Failure to do so can have serious consequences for the company's financial and legal standing. That's all from me. Thank you.